Welcome to this episode of Litigation Briefs, Media Shorts on Law and Courts. I'm Scott Dodson, a distinguished professor of law at UC Hastings College of the Law and the director of the Center for Litigation and Courts, which produces this series. The civil justice system isn't the only place to resolve disputes. Alternative dispute resolution systems exist, from rock, paper, scissors to warfare. Somewhere in between there are private systems like grievance procedures and arbitration. Arbitration has seen a rapid rise in use over the last 2 decades. So what is arbitration and what kind of a role does it play in our society today? Here to help me with these questions is my guest, Hiro Aragaki, professor of law at Loyola Law School. Hiro, welcome to the show.
It's a pleasure to be here, Scott. Thanks for having me.
Hiro, what's arbitration?
Yeah, good question. So in a nutshell, you can think of arbitration as the private equivalent of litigation. So arbitration is to litigation what a private hospital might be to a public hospital, right? Instead of going to court, you go to a private institution to have your case heard in the arbitration process. We often refer to these institutions as providers. And some of the key providers, the leading providers in the US are the American Arbitration Association, or AAA, and JAMS. Also, instead of going before a judge, who is typically an elected or an appointed government official, you go before an arbitrator who is a private citizen. They could be a former judge or retired judge. They often are lawyers, but they need not be. Another key difference between arbitration and litigation is that there's no jury in arbitration. And you might think that this is what makes arbitration exceptional, but from a global perspective, it may not be. If you think of the fact that the US really is the only country that has civil juries. In most of the rest of the world, civil cases are resolved by a sole judge hearing all the evidence. And so arbitration actually is more consistent with that, even though it does strike people as quite unusual in the sense that in the US, there is no jury in the arbitration process. Since it's a private alternative to litigation, it's something that you have to opt into, and typically that's in the form of an agreement or a contract. So you can never suddenly find yourself in an arbitration proceeding by operation of law, as you might find yourself forced to appear in a court of law. The only exception to this might be if you had somehow agreed to arbitration in a contract without really understanding or realizing that. That might come as quite a surprise to you, and I'm sure we'll talk about that issue a little bit later. Your listeners may have heard of another alternative dispute resolution process known as mediation. And arbitration and mediation often get confused, so I thought it might be helpful to just say a couple of words about that. So in arbitration, the arbitrator is very much like a judge who listens to all the evidence and the testimony and legal arguments, and is really ultimately making a final decision about who's right and who's wrong. The mediator doesn't have that power. The mediator is really just there to facilitate a settlement negotiation between the parties. The parties retain the ultimate control as to whether to settle and what that settlement looks like. And the mediator has no ability to dictate that. By contrast, in arbitration and even in court, the decision really is made by the neutral fact finder or decision maker, and the parties really have little choice in the ultimate outcome.
Why would anyone prefer arbitration to a normal court?
I guess one could also pose the question the other way around. Why would one prefer court to arbitration? But yeah, there are a couple of common reasons. So I think maybe the biggest reason why people choose arbitration is at least the promise of a faster and more efficient and less costly process. Now, there is quite a bit of noise lately about whether arbitration truly is faster and cheaper than litigation. We can talk about that a little bit later. But efficiency gains is certainly one such reason. So autonomy and party choice is another. So there's many more opportunities to exercise choice in the arbitration process than there is in litigation. So for example, in court, you are randomly assigned a judge. In arbitration, you have a say in who serves as your decision maker. And this could be very important in certain kinds of commercial cases or intellectual property cases, because you can choose a decision maker who has some kind of expertise in the subject matter. Maybe they understand the underlying technology very well. Maybe they are familiar with quirky business or industry customs and so on. Another aspect of this autonomy piece is that parties can tailor the process to fit the particular needs of a dispute. Litigation is by and large, I would say, a one-size-fits-all kind of process. And in arbitration, you get the ability really to customize things a little bit more, right? And so some examples of this might be a fast-track arbitration process where all of the deadlines are shortened, and a case that might take a year or longer could be resolved in half a year. A high-low arbitration process where the parties might agree in advance what the maximum and the minimum is that the arbitrator can award. There are a whole bunch of different bells and whistles that can be added onto, and really the sky's the limit in terms of what the parties agree to in their customization. Confidentiality, I think, is another reason that parties prefer arbitration. And I just want to clarify here that confidentiality doesn't really mean secrecy, right? Arbitration proceedings are not inherently secret like mediation proceedings are, right? So absent some kind of confidentiality agreement or some kind of rule in the provider's arbitration rules about confidentiality, a party to an arbitration can hold a press conference and reveal everything that happened in an arbitration the next day, right? Really what we mean by confidentiality in arbitration is that there's no right of public access to either the process of arbitration or the documents that are filed in arbitration, right? And so this means that the press doesn't really have access. And that is a good enough reason for many parties, just the avoidance of negative publicity and press coverage. And finally, accuracy is another reason that some parties seek arbitration out for, because they feel that it ensures results that are maybe more accurate than what could be obtained in court. If you think about it, if you have a bet the company dispute, who would you rather have decide that dispute? Is it a group of lay jurors, some of whom may or may not have any legal experience, most of whom probably don't want to be there? Or do you want a private arbitrator who has possibly decades of experience and maybe even subject matter expertise, and is probably someone who is there because they consider it their calling or their vocation to be a neutral decision maker? Another aspect of the accuracy piece is that statistically, I think more cases get to a merits hearing in arbitration than in court. And this is probably because many more cases in court either get tossed out at a preliminary stage or settle out, whereas a greater chunk actually proceed to a full-blown merits trial in arbitration. So those are maybe the four key pieces in the calculus as to why to prefer arbitration over litigation.
So let's talk about one of them for a moment, cost. Taxes, not the parties, pay the salary of a judge in the private civil justice system, but private parties, the parties themselves, they pay for the salary of the arbitrators to hear their case. So why is arbitration sometimes cheaper than court?
Yeah, and by the way, those salaries can sometimes be very, very high, right? So that's a great question. And again, there is a big debate about actually whether it is cheaper or not. And I'll set that piece aside. But I think the main answer to your question is that if arbitration is well managed, it can be shorter and quicker. And that can often mean that the attorney's costs are lower, right? And so those savings in attorney's fees can often offset any increase in costs as a result of having to hire an arbitrator. So for example, in arbitration, there's typically less discovery than there would be in court. And frankly, discovery is the costliest piece of any kind of litigation. So there alone, you might get a big savings in attorneys' fees. The other aspect of this is that I think good arbitrators tend to be very managerial and will do whatever it takes to get to a merits hearing as efficiently and quickly as possible. And one example of this is dispositive motions. So in arbitration, there is no absolute right to file a dispositive motion like a summary judgment motion, whereas in court there is. And the reality is that these motions are often unsuccessful and they can be extremely time consuming and extremely costly, right? In arbitration, the general practice is for arbitrators to require parties who want to file a dispositive motion to make a threshold showing that the motion will really help to narrow down the issues or otherwise improve the efficiency or the quality of the process. And so, for example, I sometimes sit as an arbitrator, and I have often granted such motions because, or granted leave to file such motions because I felt that they would help narrow down the scope of issues for my determination. But I've also denied them because I felt that they had very little chance of success or that they wouldn't really improve the efficiencies in the process. Let me just also mention one more thing about costs. So costs are not necessarily higher for all parties in arbitration than in litigation. So for example, employees and consumers, they really don't face that much more costs in arbitration than they would in litigation. And the reason for that is that the rules of most credible arbitration institutions like the AAA or JAMS basically require the company to pay for all of the costs of the arbitration, and anything more than what the consumer or the employee would have had to pay if the case had been in court. So for example, the remuneration of the arbitrators is not a cost that a consumer or an employee would have had to face in court. And so the providers will typically require the company to foot those costs entirely. So the costs become more for the company, but the employer or the employee or the consumer does not actually face more costs if they go to one of the reputable arbitration providers.
You mentioned customization, and let me ask this question. What are some of the key differences between the arbitration process and the litigation process?
Yeah, so one key difference I would say is that the procedural rules that we might all be familiar with, like the Federal Rules of Civil Procedure or the California Code of Civil Procedure, those kinds of rules don't apply strictly in arbitration. So as a result, parties don't get the kind of free license to conduct discovery that they would in court. And certain other features in those rules, like the ability to band together in a class or a class action, are also very uncommon in arbitration. It doesn't mean that there are no procedural rules in arbitration. It just means that they're not the same ones that would apply in a court of law. So as a result of that, certain features that one might come to expect, like discovery or class actions, are often not as robust in arbitration as they would be in court. Courtroom evidentiary rules don't strictly apply in arbitration. And that might sound like it means that evidence is difficult to introduce in arbitration or that it's somehow an evidentiary free-for-all, but it's actually kind of the opposite because the main thrust of evidentiary rules is to exclude evidence. And the idea is that if you have a lay jury that's deciding a case, there's a greater need to filter out unreliable or questionable evidence so that the jury doesn't get led astray. So the fact that there's no evidence rules, or at least that the evidence rules don't strictly apply in arbitration, given that there is a professional arbitrator rather than a jury in place, actually means that more evidence gets admitted. So I just wanted to clarify that point. On a related note regarding the lack of juries in arbitration, it could be that the fact that there's no juries has an effect on the size of punitive damages in arbitration. Punitive damages are available in arbitration in principle, just as they would be in litigation. But I think my sense is that juries tend to award greater punitive damages than arbitrators. So I don't have any empirical evidence to back this up, but it may mean, therefore, that punitive damages awards on the whole are less in arbitration than in litigation. Another difference that's commonly noted is that arbitrators are not strictly bound by the substantive law as trial courts are and appellate courts are. Although I have to say that respectable arbitrators, as a rule, will follow the law. And just as a bit of background, the idea behind this principle that originated many centuries ago was that sometimes strictly applying the law produces the wrong result, or a result that wouldn't be considered by most people to be just. And so the rationale behind this rule historically was that it gives arbitrators the discretion to do equity in limited cases where that kind of thing might happen. Connected to this, there's also no right of appeal in arbitration, right? So in court, you're generally given one appeal as of right. And of course, an appeal is not a do-over, it's not a second bite at the apple. The primary purpose really is just to correct legal errors. But there is no real appellate mechanism by default in arbitration. You talked about customization. It's certainly something that people can customize and write into their arbitration process, but that's a pretty rare occurrence, I think. This is not to say that the arbitrator's decision can't be challenged at all. It can be, but typically the grounds for challenge or so-called appeal in arbitration are limited, and they're limited to procedural grounds, things like bias of the arbitrator or conflicts of interest of the arbitrator. Or perhaps the arbitrator didn't afford one party an adequate opportunity to present their witnesses or their evidence. And so that borders on a kind of due process problem, right? Or maybe the arbitrators exceeded the authority that they were given in their arbitration clause. So these are the kinds of bases on which arbitration awards can be overturned. And these are the main differences between the two processes. And I have to say, because you touched on customization, ultimately arbitration is a creature of contracts. It's really whatever the parties dream it up to be, right? And I have seen arbitration agreements that actually say, in this arbitration, the arbitrators must follow to the letter the federal rules of civil procedure and the federal rules of evidence. I've also seen agreements that say the arbitrator must strictly follow the applicable governing law, and that if the arbitrator creates any legal errors, that those errors can be appealed to a private appellate arbitration tribunal, right? So basically building in an appellate procedure into their arbitration process. Not sure that I would recommend any of these things really in an arbitration clause, but it just goes to show that while there are, I think, main or salient differences between these two processes, really it's whatever the parties agree to. And sometimes arbitration can look very much like litigation. In fact, that's one of the criticisms recently, is that arbitration has kind of evolved into the quote unquote new litigation.
What other downsides are there to arbitration?
Yeah, so downsides, certainly there are. I think one of the key ones that is often mentioned is the lack of publicity or the lack of public access, which can mean that important evidence about systemic wrongdoing may never come to light, right? So for example, if there's pervasive problems at a company, maybe pervasive sexual harassment or discrimination, if everything is in a private forum like arbitration, where the press doesn't have public access, it may be that we don't come to know about some of these pervasive issues that affect society at large. Arbitration doesn't produce published precedent like appellate courts do. So some people argue that arbitration is problematic in that it doesn't really contribute to the evolution and development of the law through precedents. Arbitration is a process, as I said earlier, that's born of a private agreement or a contract. And the reality is that contracts often favor the party with greater bargaining power, right? And so the stronger party is really in a better position to dictate certain terms. So for example, the stronger party could include in an arbitration clause a forum selection clause. So this would be a clause that says, to the extent we have a dispute and it gets arbitrated, it has to be arbitrated in my home state. So if I'm located in Florida, but you're in Alaska, that means that you have to travel from Alaska to Florida, and that can be very unfair, right? Class arbitration waivers or class action waivers is another kind of clause. This is a clause that prohibits weaker parties from banding together as a class, which is an important mechanism sometimes to equalize the leveling field between parties to a dispute. There are a whole host of other clauses that can be included in arbitration clauses, like clauses limiting remedies or shortening statute of limitations and so on. Now, to be clear, many of these clauses can also be found in contracts that contemplate litigation for the resolution of future disputes. So what I want to emphasize here is that there's nothing inherent in the nature of arbitration that means, for example, that parties can't band together as a class. Class waivers can, in principle, be used in litigation as well. I think the main difference is that current arbitration law makes it harder for states and the federal government to place restrictions on these kinds of clauses. In other words, it's much easier to regulate and restrict these kinds of clauses in the litigation process. So there's nothing really stopping us from having class arbitration. And in fact, many providers have class arbitration rules. But because of the way the law in this area has evolved, it's very difficult for the states and the federal government to make it so that contracts that waive these protections are rendered unenforceable.
So that's a great discussion and description of how arbitration works. How do litigants decide to arbitrate a dispute rather than to litigate?
Yeah, so that's also a great question. And the key word here is decide, because some parties will say, well, we didn't really decide because we didn't really have a choice in the matter. And this often happens where there's a power dynamic between the parties. So as I said earlier, because arbitration is not the default of court, you have to sort of opt into it in order to use it, right? And the way you do that is through an agreement, typically a contract. And there are two different types of agreements. One is what we think of as a pre-dispute agreement. To arbitrate, that would be either a standalone agreement or an arbitration clause in a service contract or a sales contract that you might have entered into. These are the ones really that are the most controversial, because when you sign up for an internet service or you get hired for a job, you're typically concerned about things like, what price am I paying, right? What services am I getting? What is the compensation I'm getting if I'm being employed? And you typically don't focus on, well, what will happen if we end up having a conflict or a dispute, right? But that is the primary way, I would say, that parties enter into arbitration. And the counter argument here is that pre-dispute arbitration clauses are much more effective, because once a dispute arises, the parties typically can't agree on anything, let alone the process that they might use to best resolve it. And so that by pre-committing themselves in a pre-dispute clause, that's just more effective. So the key thing about these pre-dispute clauses, again, is that the dispute hasn't arisen yet. So the parties don't really know what kind of dispute they might end up arbitrating, and they're usually not very focused on the arbitration process when they agree to it. The other type of agreement is what's known as a post-dispute or submission agreement. That's where the dispute has already arisen. So for example, it could be an employee who has, maybe they filed a lawsuit, or maybe they haven't filed a lawsuit yet, but they've made some claims about discrimination or retaliation in the workplace, right? So the dispute is there, and the parties, for whatever reason, decide, hey, I think we might be better off in arbitration than in litigation. Let's sign this post-dispute arbitration agreement. These are comparatively much more infrequent than the pre-dispute type, although I have to say that after COVID, there's been a little bit of an increase in the use of these kinds of agreements. As you know, after COVID, a lot of the courts had to shut down for a period of time. There were massive delays and backlogs. And even plaintiff side lawyers were kind of scratching their heads and thinking, well, are we actually better off in arbitration, where we might get a hearing via Zoom, in the next 6 months or a year, or do we want to wait the next 2 years for an actual court date? And we did see a little bit of an uptick in post-dispute clauses after that. Typically these agreements will make clear that the arbitration process is final and binding. which means that if you don't agree with the arbitrator's decision, you don't have a recourse to the courts thereafter. You're really bound by that. You have to accept that award. But some agreements don't do that. Some agreements are not final, but they tend to be much more the exception than the rule. Usually the agreements are what are known as broad form arbitration clauses, which means that the parties are agreeing to submit any and all disputes that are related to their relationship to arbitration. But it doesn't have to be that way. Just because most clauses are that way doesn't mean that you can't craft an agreement that says we only want this type of dispute to go to arbitration, all the rest can go to court. So there's lots of flexibility there. Finally, there are some kinds of disputes that just can't be arbitrated no matter how much the parties may want to. And a good example of that is core bankruptcy claims. So these are claims that typically involve the rights of third-party creditors. In rem claims, which means claims about ownership of physical or intellectual property that might involve potential claims of third parties. Criminal charges, right? If you ever get charged with a crime, the DA can never tell you, I'm taking you to arbitration. Arbitration is just not possible in the criminal context at all.
With respect to the pre-litigation agreements, what kind of agreements are those? I mean, is it possible that I've actually agreed to an arbitration clause somewhere?
Yes, it is most likely the case if you live not like a hermit and like most of us, that you have a cell phone, which means that you most likely have a arbitration clause, because the vast majority, if not all, of the main cell phone providers have included arbitration clauses. So that is true. Most of us in this day and age have probably signed an arbitration clause at some point or another. Another area in which you often find arbitration clauses is doctors and dentists' office. So if you go to a new doctor or dentist next time, chances are the intake form will have an arbitration clause in it. Employment agreements often do have arbitration clauses in them. Credit card agreements are also common. Partnership agreements I've seen. It really runs the gamut.
What can I do if I don't want to be bound by one of these arbitration clauses?
Yes. So that's a good question too. It really depends, I think, on the relationship that you have with the other party. So if you have some bargaining or negotiating power, you can always suggest to the other party, hey, I notice you included this arbitration clause. I'm not really comfortable with that. What about if I make some concession on the price or this or that, and we remove the arbitration clause? So that would be one way that you could avoid arbitration. If you don't have that kind of power, so for example, if you're signing up with a cell phone provider, the reality is that you don't have that bargaining power. So your only real choice is to decline the service entirely, which again, unless you really want to live like a hermit, is not really realistic for most of us, right? I should note that there is something known as the Forced Arbitration Injustice Repeal Act, or the FAIR Act, F-A-I-R is the acronym, pending in Congress, which would invalidate certain types of arbitration clauses in pre-dispute agreements, mainly in the employment, consumer, I think it's civil rights and antitrust contexts, right? There have been many similar initiatives like this in the past in Congress, going back maybe 10 years or even more, but they've always been unsuccessful. They've never really garnered enough political support. Given the changing tides in Congress more recently, it may be that things will be different this time around with the FAIR Act. If the act passes, I think the upshot for those of us with lesser bargaining power in certain contexts is that we might have really more real choice when it comes to deciding if we want to arbitrate or dispute or not.
Hiro, thanks for being on the show and for explaining arbitration and arbitration agreements.
You're very welcome. Thanks so much for having me, Scott. It was really fun.
This episode was produced by the Center for Litigation and Courts at UC Hastings College of the Law. If you enjoyed this episode of Litigation Briefs, I hope you'll tune in to future episodes. And in fact, I hope you'll consider subscribing to our YouTube channel and audio podcast, which can be accessed through the Center for Litigation and Courts website at sites.uchastings.edu litigation.com/CLC. While you're at it, encourage a friend to do the same. This is Litigation Briefs. Respectfully submitted, Scott Dodson.